Hello everyone, this is Advocate Anila Jayaprakash. Welcome to Legal Desk. When we talk about cruelty against married women in India, one provision immediately comes to mind. What people popularly known as Section 498A of IPC. After the new criminal laws came into force, this provision now exists, Section 85 of the BNS. The number has changed, the statute has changed, but the nature of the offence, the seriousness of the consequences, and the social impact remain exactly the same. This law was introduced with a very clear and noble purpose. For decades, cruelty inside marriage was treated as a private family matter. Dowry harassment is normalized. Women were told to adjust, tolerate, and remain silent. Parliament stepped it in, and Section 498A of IPC, now Section 85 of BNS, was enacted to protect married women from cruelty, harassment, and dowry demands. It was meant to act as a shield. It was meant to deter abuse. It was meant to give a woman a voice backed by criminal law. However, a very strong law carries a responsibility. When a provision gives a power of arrest, prosecution, and imprisonment, it must be used carefully, and over the years, court began to notice that this provision was often being used not only against the husband but mechanically against every member of his family, aged parents, siblings, elderly relatives, and even people living separately with no involvement in the marriage. It is in the background that the Honorable Supreme Court of India has repeatedly stepped in to draw a line between the genuine case and abuse of process. The case we are discussing today is a classic example of this judicial approach. In this case, the wife filed a criminal complaint alleging cruelty and dowry harassment. Along with her husband, she also named his parents. Was not that they personally demanded dowry or directly assaulted her. Her allegation that they instigated the husband. According to her, because they were his parents, they must have influenced him to demand dowry and subject her to mental cruelty. This case did not end at the trial court. It traveled through the system, consuming years of judicial time until it finally reached the Honorable Supreme Court of India. When this Honorable Supreme Court examined the complaint, it did not look at it emotionally, it looked at it legally. It looked at what was actually written, not what was assumed, and what the court found was deeply significant. The complaint did not mention any specific incident involving the parents. There was no date mentioned when the parents allegedly instigated the husband. There was no place where such instigation occurred. There was no allegation of any specific act committed by either the father-in-law or mother-in-law. The complaint was silent on all material particulars. More importantly, there were not a single piece of material evidence to show that parents had demanded dowry or participated in harassment. No messages, no letters, no witness, no documents, nothing. The entire case against the parents was built on a presumption that they are parents, they must have played a role. The Honorable Supreme Court of India made it clear that criminal law does not operate on presumptions of this nature. Criminal liability is a personal, it is individual. A person can be prosecuted only for what he or she has done, not for what someone else might have done, and certainly not merely because of a family relationship. The Honorable Court reiterated a principle that it was well settled but often forgotten that vague omnibus and general allegations are not sufficient to sustain a criminal prosecution, especially under a serious provision like Section 85 of BNS. Courts cannot allow a trial to continue when there is no clear attribution of role, no specific act, and no supporting material. The Honorable Supreme Court of India therefore quashed the proceedings against the parents. And this decision was not based on sympathy, it was based on law, it was based on due process, it was based on the fundamental principle that liberty cannot be taken away casually. The Honorable Court also took note of the serious consequences that follow once a case under this provision is registered, arrest becomes possible, reputation is damaged, social stigma follows immediately, elderly parents are dragged to police stations and courts. Careers are affected, mental health suffers. All of this happen even before guilt is established. That is why the Honorable Court emphasized that Section 85 of BNS, Section 498A of IPC must be applied with precision. Strong law cannot be allowed to become tools of pressure or revenge. They must remain instrument of justice. It is very important to understand this judgment is not anti women. It does not dilute protection for genuine victims. On the contrary, it protects the credibility of the law. When court prevent misuse, they ensures that genuine cases are taken seriously and not lost in flood of exaggerated complaints. The Honorable Supreme Court of India made it clear that being a member of the husband family does not automatically attract of criminal liability. Relationship alone is not a crime. Suspicion alone is not proof. And assumption alone is not an evidence. This principle applies with equal force under the Bharatiya Nyaya Sanhita. Changing the statutes does not change constitutional safeguards. Due process remains the backbone of criminal law. The message from the Honorable Supreme Court is therefore very clear. Section 85 of the BNS is a protective provision, not a punitive shortcut. It is shield for those who are genuinely subject to cruelty, not a sword to strike indiscriminately at an entire family. Criminal law is not meant to provide emotional satisfaction. It is not a forum for settling personal scores. It is a serious legal mechanism meant to punish real offenders based on proof, not perception. Justice does not work on assumptions. Justice works on evidence. Section 498A of IPC or Section 85 of BNS is a shield, not a sword. It is meant to punish real offenders, not to be used as a weapon against the entire family. Criminal law is not meant to satisfy anger or emotion. It is meant to deliver justice based on evidence, and that is exactly what the Honorable Supreme Court has reaffirmed here. Recently, Honorable High Court of Karnataka delivered a very clear judgment. Can a neighbor be sent to jail under Section 498A of IPC just because he or she allegedly supported husband? Today, I will tell you why the Karnataka High Court says no and why this judgment is extremely important for common people. In many matrimonial disputes, we see a dangerous trend. along with the husband and in-laws, neighbors, friends, even distant acquaintances are added as a accused under Section 498A of IPC. The Honorable High Court of Karnataka gave a very clear answer. The Honorable Court held that a neighbor is an outsider. Mere proximity or familiarity does not create a legal relationship. The term relative must be strictly interpreted. Therefore, prosecution of a neighbor under Section 498A of IPC is not maintainable. This ruling of Honorable Karnataka High Court is a big relief for neighbors, friends, well-wishers, landlords, and colleagues. If such persons are falsely implicated, the Honorable High Court can quash the proceedings. Police must be careful in filing charge sheets. Mechanical inclusion of accused is illegal. Section 498A of IPC is a protective law, not a weapon. Misuse of this provision weakens the genuine cases and harasses the innocent people. Justice is not about numbers of accused. It is about legal responsibility. Neighbor is not a relative of the husband. Hence, Section 498A of IPC cannot be invoked against neighbor. Remember this clearly. Criminal law is not meant for revenge. Section 498A of IPC or Section 85 of BNS a specific purpose and it has specific limits. A neighbor is not a relative of the husband, and dragging innocent third parties into criminal cases is an abuse of law. Court are now stepping in to stop this misuse. Know your rights, respect the law. Law must protect the innocent and punish only the guilty. Section 498A of IPC or Section 85 of BNS cannot be stretched beyond its limits. This is not just a judgment, it is a reminder that rule of law still matters. Thank you for watching. If you like this video, please like, share and subscribe. Thank you.